Welcome to UPSC new topic. It was in 1934 that the idea of the Constitutional Assembly for India was put forward for the first time by M.N. Roy, a pioneer of communist movement in India. In 1935, Indian National Congress for the first time officially demanded a Constitutional Assembly for the frame of the Constitution of India. In 1935, Indian National Congress for the first time officially demanded the Constitutional Assembly to frame the Constitution of India. In 1938, Jawaharlal Nehru, on the behalf of the Indian National Congress, declared that the Constitution of Free India must be framed without outside interference by the Constitutional Assembly elected on the basis of the oral franchise. The Constitutional Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The features of the scheme were: total strength of the Constitutional Assembly was to be 389. Of these, 296 seats were to be allotted to British India and 93 seats to the princely state. Out of 296 seats allotted to the British India, 292 members were to be drawn from the 11 governor provinces and 4 from the chief commissioner provinces, 1 from each. Each province and princely state or a group of the state, in case of the small state, were to be allotted seats in the proportion to their respective population. Roughly 1 seat was to be allotted for every million population. Seats allocated to each British provinces were to be divided among the 3 principal communities: Muslim, Sikh and General, all except Muslim and Sikh, in proportion to their population. The representative of each community were to be elected by the members of the community in the provincial legislative assembly, and voting was to be by the method of proportional representation by means of single transferable vote. The representative of the princely state were to be nominated by the heads of the princely state. It is thus clearly that the Constitutional Assembly was to be partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assembly, who themselves were elected on the limited franchise. The election to the Constitutional Assembly for 296 seats allotted to the British Indian provinces were held in July-August 1946. The Indian National Congress won 208 seats, the Muslim League 73 seats, and the small groups and independent got the remaining 15 seats. However, the 19 seats allotted to the princely state were not filled as they decided to stay away from the Constitutional Assembly. New topic. At present, 2019, the 8th schedule of the Constitution specified 22 languages, originally 14 languages. These are Assamese, Bengali, Bodo, Dongri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Maithili, Malayalam, Manipuri, Marathi, Nepali, Odia, Punjabi, Sanskriti, Santhali, Sindhi, Tamil, Telugu and Urdu. Sindhi was added by the 21st Amendment Act of 1967. Konkani, Manipuri, Nepali were added by the 71st Amendment Act of 1992. Bodo, Dongri, Maithili, Santali were added by the 92 Amendment Act of 2003. English is not listed in 8th schedule. In terms of the constitution provision, there are 2 objectives behind the specification of the aboriginal language in the 8th schedule. The members of these languages are to be given representation in the Official Language Commission. The forms, style, expression of this language are to be used for the enrichment of the Hindi language. New topic. Democracy is the 2 types, direct and indirect. In direct democracy, the people exercise their supreme power directly, as is the case in Switzerland. There are 4 devices of direct democracy, namely referendum, initiative, recall, and plebiscite. Indirect democracy, on the other hand, representatives elected by the peoples exercise the supreme power and thus carry on the government and make the laws. This type of democracy also known as representative democracy. Referendum is a procedure whereby proposed legislation is referred to the electorate for the settlement by their direct votes. Initiatives is a method by means of which the people can propose a bill to legislature for enactment. Recall. Recall is the method by means of which the voters can remove representative or officer before the expiry of his term when he fails to discharge his duty properly. Plebiscite is the method of obtaining the opinion of the people on any issue of the public importance. It is generally used to solve the territorial dispute. New topic. Article 1 describes India, that is Bharat, as a union of the state rather than federation of the state. This provision deals with the two things: one, name of the country, and two, type of the polity. Secondly, the country is described as a union, although its constitution is federal in structure. According to B.R. Ambedkar, the phrases of the union of states has been preferred to federation of the state for two reasons. One, the Indian Federation is not the result of an agreement among the states like American Federation, and two, states have no right to succeed from the federation. According to Article 1, territory of India can be classified into three categories: territories of the state, union territories, territories that may be acquired by the government of India at any time. Name of the states and union territories and their territorial extent are mentioned in the first schedule of the constitution. At the present, there are 28 states and 8 union territories. New topic. Recently, Union Cabinet approved 20,000 crore budget for National Green Hydrogen Mission. Grey hydrogen is the most common form of hydrogen. It is generated from natural gas or methane through a process called steam reforming. In this process, natural gas containing methane (CH4) can be used to produce hydrogen with thermal processes such as steam methane reformation and partial oxidation. Hydrogen can be produced from range of the resources including fossil fuels, nuclear energy, biomass, renewable energy source. Depending on the production of the method, hydrogen can be gray, blue or green, and sometimes even pink, yellow or turquoise. They are essentially color codes used within the energy industry to differentiate between the types of the hydrogen. Depending on the type of production used, different colors are assigned to the hydrogen. Hydrogen emits only water. Hydrogen emits only water when burned. It drives the gray hydrogen name because of the process of the production and not on the basis of the byproduct after burning. Green hydrogen is the only type produced in the climate neutral manner, meaning it could play a vital role in the global effort to reduce the emission to net zero by 2015. New topic. The Government of Indian Act of 1999 was enacted and came into force in 1921. This act is also known as Montego Chelmsford Reforms, or Montego was the Secretary of the State for India and Lord Chelmsford was Viceroy of India. Features of this act were as follows. It relaxed the central control over the provinces by democratic and separating the central and the provincial subject. The central and provincial legislature were authorized to make laws on their respective list of the subject. However, the structure of government continued to be centralized and unitary. It further divided the provincial subject into two parts: transfer and reserve. The, the transfer subject were to be administered by the governor with the aid of the minister responsible to legislative counseling. The reserve subject, on the other hand, were to be administered by the governor and his executive counseling without being responsible to the legislative counseling. This dual scheme of the governance was known as Diarche. It required that the three of the six members of the Viceroy Executive Council, other than the commander-in-chiefs, were to be Indian. It extended the principle of the communal representation by providing separate electorates for the Sikh, Indian Christians, Anglo-Indians, and Europeans. It, grant, it granted franchise to limited number of the people on the basis of the property, tax, or education. It created a new office of the High Commissioner for India in London and transferred to him some of the function he to perform by Secretary of the State for India. It provided for establishment of the Public Service Commission. In Central Public Service Commission was set up in 1926 for the recruiting civil servant. It separated for the first time provincial budget from the central budget and authorized the provincial legislature to enact their budget. New topic. Center has named its new integrated food security scheme for providing free food grain to Antyodaya Anna Yojana and primary household beneficiary under the National Food Security Act 2013 as Pradhan Mantri Garib Kalyan Anna Yojana. It will strengthen the provision of the National Food Security Act 2013 in terms of the accessibility, affordability, availability of the food grain for the poor. It will subsume two subsidy schemes of the Department of Food and Public Distribution. Food subsidy to Food Corporation of India. It is in the form of the consumer subsidy. Difference between the economic cost incurred by the Food Corporation of India and realize the central issue price, and a buffer subsidies, cost of holding and maintaining buffer stock. Food subsidy for decentralized procurement state dealing with the procurement, allocation and delivery of free food grains to state under National Food Security Act. Earlier scheme with the similar name, Pradhan Mantri Garib Kalyan Anna Yojana, was implemented during the COVID-19 pandemic. Difference between the two schemes. Earlier, National Food Security Act beneficiaries were getting food grain entitlements 35 kg per Antyodaya Anna Yojana household and 5 kg per person to priority PHH at the subsidized rate rupees 3 per kg rice, rupees 2 per kg wheat and rupees 1 kg per coarse grains. Now the government has done away with the subsidized price and providing food grains free of cost for a year. However, an additional quantity of 5 kg of the food grain will not be provided. New topic. Constitution. Article 1865 has provided for the office of the Advocate General for the state. He is the highest law officer in the state. Article 165, Advocate General for the state. The term of the office of the Advocate General is not fixed by the Constitution. Further, the Constitution does not contain the procedure and grounds for his removal. He holds office at the pleasure of the Governor. This means that he may be removed by the Governor at any time. In the performance of his official duties, the Advocate General is entitled to appear before any court of law within the state. Further, he has the right to speak and to take a part in the proceedings of both the houses of the state legislature or any committee of the state legislature of which he may be named a member, but without right to vote. He enjoys all the privileges and immunities that are available to the member of the state legislature. New topic. Food Safety Standard Authority of India survey stated that 15% of the dietary supplement were found to be unsafe for consumption. Unsupervised consumption of the dietary supplements, warning poor quality products, can affect the cardiovascular health and kidneys. Food Safety and Standard Authority of India is under Ministry of the Health and Family Welfare. It is an autonomous statutory body established under the Food Safety and Standard Act 2006. Food Safety and Standard Authority Act 2006 consolidated various acts and orders that had earlier handle food related issue in the various ministry. It regulates and monitors manufacturing, processing, distribution of the food while ensuring safe and wholesome food to the consumer. Headquarter Delhi. New topic. In the Vaman Rao case 1981, The Supreme Court adhered to the doctrine of the basic structure and further clarified that it would be applied to the constitutional amendment enacted after April 24, 1973. Court in Vaman Rao versus Union of India ultimately ruled that the first Constitutional Amendment Act of 1951 that introduced Article 31A, 31B, as well as the 25th Amendment Act that introduced Article 31C were constitutional and did not damage any basic or essential features or basic structure of the Constitution. Yes, R. Bommai case 1994. The verdict concluded that the power of the President to dismiss a state government is not absolute. The verdict said the President should exercise the power only after his proclamation imposing his or her rule is approved by both the House of Parliament. Till then, the court said the President can only suspend the Legislative Assembly by suspending the provision of the Constitution related to the Legislative Assembly. Kuldeep Nair case 2006. The case of Kuldeep Nair versus Union of India 2006 deals with the amendments to the Representation of the People Act 1951, where initially it required for the electorate to have domicile in the state concerned for getting elected to the council of the state, which was subsequently deleted by the said amendment in 2003. Indira Gandhi Nehru case 1975. The doctrine of the basic structure of the constitution was reaffirmed and applied by the Supreme Court in the Indira Nehru Gandhi case 1975. In this case, Supreme Court invalidated a provision of 39 Amendment Act 1975, which kept the election dispute involving the Prime Minister and the Speaker of the Lok Sabha outside the jurisdiction of all the courts. New topic. Collective responsibility is the convention under which individual members of the government are held accountable for acts and decisions of the government as a whole. Under the Constitution of India, Article 75(3) deals with the collective responsibility at the center. The Council of Ministers shall be collective responsible to the House of the People, while Article 164(3) deals with the state government. Recently, Supreme Court stated a statement made by the ministry, even if traceable to any affairs of the state or for protecting the government, cannot be attributed vicariously to the government by evoking the principle of the collective responsibility. In other words, the flow of the stream in the collective responsibility is the from the council of minister to the individual minister and not vice versa. New topic. Federalism. Federalism is the system of government in which the power is divided between the central authority and various constitutional units of the country. Usually, a federation has two levels of the government. One is the government for the entire country that is usually responsible for few subjects of common national interest. Other are governments at the levels of provinces or state that look after much of the day-to-day administrating of the state. Both these level of government enjoy the power independent of the other. Features of federalism. There are two or more levels or tiers of the government. Different tiers of the government govern the same citizen, but each tier has its own jurisdiction in the specific matter of legislation, taxation, and administration. Jurisdiction of the respective levels of or tiers of the government are specified in the constitution. So the existence and authority of the each tier of the government is constitutionally guaranteed. The fundamental provision of the constitution cannot be unilaterally changed by one level of the government. Such a change requires consent of both the levels of the government. Courts have the power to interpret the constitution and the power of different levels of the government. Highest court act as the umpire if the dispute arises between the different levels of the government in the exercise of their respective power. Source of revenue for each level of the government are clearly specified to ensure its financial autonomy. New topic. Among all the committees of the Constitutional Assembly, the most important committee was Drafting Committee, set up on August 29, 1947. It was this committee that was entrusted with the task of preparing a draft of the new constitution. It consists of the 7 members. They were Dr. B.R. Ambedkar, Chairman, N. Gopalaswamy Iyengar, Aladi Krishnaswamy Iyer, Dr. K. M. Munshi, Syed Mohammad Sadullah, N. Madhava Rao, T. T. Krishnamachari. The drafting committee, after taking into consideration the proposal of the various committee, prepared the first draft of the Constitution of India, which was published in February 1948. The people of India were given 8 months to discuss the draft and propose amendments. New topic. Recent contest काय the union government has informed that cadastral map of 35% of over 6 lakh villages in the country have so far been geo-referenced under the Digital India Land Records Modernization Program. Digital India Land Records Modernization Program. Cadastral maps are digitalized form of land record that show all the boundaries of different parts of the land species based on their length, area, and direction. DILRMP is implemented by the Department of Land Resources under the Ministry of Rural Development. It is a central sector scheme that has been extended to 2023-24 to complete its original target as well as expand its ambit with the slew of new schemes. Its three major components: computerization of the land record, survey or resurvey, computerization of the registration. New topic. Central Vigilance Commission is the main agency for preventing corruption in the central government. It was established in 1964 by the executive resolution of the central government. Its establishment was recommended by Santhanam Committee on the Prevention of the Corruption 1962-1964. Central Vigilance Commission is a multi-member body consisting of the Central Vigilance Commissioner, Chairman, and not more than 2 Vigilance Commissioners. They are appointed by the President by the warrant under his hand and seal on the recommendation of 3-member committee consisting of the Prime Minister as its head, Union Minister of the Home Affairs, and the leader of the opposition in the Lok Sabha. They hold office for a term of 4 years or until they attain the age of the 65 years, whichever is earlier. After their tenure, they are not eligible for further employment under the central government or state government. The salary, allowances, or other conditions of the service of the Central Vigilance Commission are similar to those of the chairman of the UPSC, and that of the Vigilance Commissioner are similar to those of the member of UPSC. But they cannot be varied to this disadvantage after his appointment. New topic. The Constitution 101st Amendment Act 2016 passed the 8th September 2016. Since the GST Council has been notified, bringing into existence the constitutional body to decide the issue relating to GST, insert a new Article 279A in the Constitution. This article empowers the President to constitute GST Council by order. According to the President issued the order in 2016 and constituted the Council. As per Article 279A of the Constitution, of the amendment in the Constitution, the GST Council, which will be a joint forum of the center and the state, shall consist of the following member: Union Finance Minister, Chairperson; Union Minister of the State in the charge of the revenue of the finance, member; Minister in charge of the finance or taxation, or any other minister nominated by the each state government, members. As per the Article 279A(4), the Council will make recommendation to the Union and State on the important issue related to GST, like the goods and services that may be subjected or exempted from GST, model GST laws, principle that govern the place of supply, threshold limit, GST rates including the floor rates with bands, special rates for raising the additional resource during the national calamities and or disaster, special provision for certain state, etc. Secretariat of the Council is located in New Delhi. The Union Revenue Secretary acts as the ex-officio secretary to the Council. New topic. The National Commission on Protection of the Child Rights has been constituted by the Government of India under the Commission for Protection of the Child Rights Act 2005 to exercise and perform the powers and function assigned to it under the Commission for Protection of the Child Rights Act 2005. The Commission works under the aegis of the Minister of Women and Child Development. The Commission consists of the following members, namely Chairperson, who is a person of eminence and has done outstanding work for promoting the welfare of the children. 6 members, out of which at least two are women, are appointed by the central government. For the function of the National Commission for Protection of the Child Rights has laid out in the Commission for Protection of the Child Rights Act 2005 are as follows. Examine and review the safeguard provided by the or under any law for the time being in force for the protection of the child rights and recommended measures for their effective implementation. Inquire into the complaints and take suo motu notice of the matter relating to deprivation and violation of the child rights, non-implementation of the laws providing for the protection and development of the children, non-compliance of the policy decision, guidelines or instruction at mitigating the hardships to and ensure the welfare of the children and provide relief to such children. Inspect or causes to be inspected any juvenile custodial home or any other places of residence or institution meant for children under the control of the central government or any state government or any other authority, including any institution run by the social organization. Spread children's right literacy among the various sections of the society and promote the awareness of the safeguard available for the protection of these rights through publication, the media, seminar, other available means. New topic. Central Information Commission is a statutory body set up under the Right to Information Act 2005 under the Government of India to act upon complaints from those individuals who have not been able to submit information requests to the Central Public Information Officer or State Public Information Officer due to either the officer not have been appointment or because the respective Central Assistant Public Information Officer or State Assistant Public Information Officer refused to receive the application for information under the Right to Information Act. However, newly amendment Act, Right to Information Act Amendment 2019 empower the central government to prescribe the terms of the office for the commissioner as it may be deemed fit to the government. Before this amendment, their term was fixed for 5 years. The 2019 Amendment Act also stated that the salary, allowance and other service condition of the Chief Information Commissioner and Information Commissioner of the central as well as the state shall be such as prescribed by the central government. Before this amendment, salary, allowances and other service conditions of the Chief Information Commissioner were similar to those of the Chief Election Commissioner, and that of the Information Commissioner were similar to those of the Election Commission, State Election Commissioner in case of the state. The Commission consists of the Chief Information Commissioner, not more than 10 Information Commissioner. The Commission, when constituted initially, had 5 Commissioners including Chief Information Commissioner. President can remove the Chief Information Commissioner or any Information Commissioner from office under the following circumstances: if he is adjudicted insolvent, or if he has been convicted of the offences which in the opinion of the President involves a moral turpitude, or if he engaged during his term of office in any paid employment outside the duties of his office, or if he is in the opinion of the President unfit to continue in the office due to infirmity of mind or body, if he has acquired such a financial or other interest as is likely to be affect the prejudicially his official function. In addition to this, the President can also remove the Chief Information Commissioner or any Information Commissioner on the grounds of proven misbehavior or incapacity. However, in these cases, the President has to refer the matter to the Supreme Court for an inquiry. If the Supreme Court after the inquiry uphold the causes of the removal and advises so, then the President can remove him. The Commission submit an annual report to the central government on the implementation of the provision of this act. The central government places this report before each house of the parliament. New topic: provision under DPSP with relevant constitutional articles to promote the cottage industry on the individuals or corporations basis in the rural areas. Article 43. to promote the cottage industry on the individual or cooperation basis in rural areas, to prohibit the consumption of the intoxicant drinks and drugs which are injurious to the health, Article 47, to prohibit the slaughters of the cows, calves, and other milches and cattle and to improve their breeds, Article 48, to organize agriculture and animal husbandry on a modern and scientific lines, Article 48, to protect and improve the environment and to safeguard the forest and wildlife, Article 48A, to protect and improve the environment and to safeguard the forest and wildlife, Article 48A. New topic. American Constitution was first to begin with the preamble. Many countries, including India, follow this practice. The term preamble refers to introduction or preface to the Constitution. To the Constitution. It contains the summary or essence of the Constitution. Preamble to the Indian Constitution is based on the objective resolution drafted and moved by the Pandit Nehru and adopted by the Constitutional Assembly. It has been amended by the 42 Constitutional Amendment Act of 1976, which added three new words: socialist, secular, integrity. It added three new words: socialist, secular, and integrity. Originally, 1949, the Constitution contains a preamble, 395 articles divided into 22 parts, and 8 schedules. 395 articles divided into 22 parts and 8 schedules. Preamble reveals four ingredients or components. Source of the authority of the Constitution. The preamble stated that the Constitution derives its authority from the people of India. Source of the authority of the Indian Constitution derives its authority from the people of India. Nature of the Indian state. It declares India to be of sovereign, socialist, secular, democratic, and republic polity. Objective of the Constitution. It specifies the justice, liberty, equality, fraternity as the objective. Date of adoption of the Constitution. It stipulated November 26, 1949 as the date. In Birubari Union Case 1960, Supreme Court said that the preamble show the general purpose behind the several provision in the Constitution and is thus key to the minds of the makers of the Constitution. Further, where the terms used in any articles are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objective instruction in the preamble. Despite this recognition of the significance of the preamble, the Supreme Court specified that the preamble is not a part of the Constitution. The above opinion was reversed in the Keshwananda Bharti case in 1973. Supreme Court held that the preamble is the part of the Constitution. This opinion was further clarified by the Supreme Court in the LIC of India case 1995. New topic. Recent votive stupas or offer in fulfillment of the vow were discovered by the Archaeological Survey of India near Saraitila Mount within the premises of Nalanda Mahavira in Bihar. Stupa, Sanskrit for hip, is a mound-like hemispherical burial structure containing relics of Buddhist monk. Example, Sanchi Stup, built over Buddha relics. About Nalanda Mahavira. It is a UNESCO World Heritage Site with archaeological remains of a monastic and scholastic institution from the 3rd century before Common Era to the 13th century Common Era. Gautam Buddha as well as the Mahavira stay at Nalanda. Other famous scholars at the Nalanda: Nagarjuna, Dharmapala, Dinanga, Jinamitra, Santarakshita. Eminent pilgrimage monks like Huyanti Sang, I.T. Singh also visited. It prospered under Gupta dynasty, Harsha or Kannauj, and Pala dynasty. Gupta dynasty, Harsha of Kannauj, and Pala dynasty. It includes stupas, shrines, viharas, residential and educational building, and important artwork in stucco, stone, and metals. Thank you so much.